planning work. So let Vijaya introduce herself.
Hi, everybody. Thanks for coming in. I'm Vijaya Singh. I've been at VIP since 2021 and loving it. I'll give it back to Lindsay.
Okay, we'll take it from there and just talk a little bit about VIP and what our mission is. And one of the, key things that we like to highlight is that we are a leveraging model, which means we as a very small staff are leveraging the resources of the Philadelphia legal community to help as many low-income Philadelphians as possible and close that gap in the access to justice and really allowing people to have access to resources they wouldn't otherwise be able to have. Philadelphia is the largest core city in the US, and there is a huge gap in access to legal services. So VIP was founded in the early 80s when funding was cut to legal services, and we became the pro bono arm of the Bar Association to help bring in private attorneys to fill that gap. And we have only grown from there and have gone to helping hundreds of clients a year. Thousands of Philadelphia volunteers participate with us each year, but there is always room for more, and there is always a demand for legal services. And so we really appreciate you taking the time to attend this training to learn more about this issue. And for all of you who volunteer with us, we are really, really grateful. So our clients are at or below, for estate planning purposes, 300% of the federal poverty guidelines. But you'll see many of our clients are even lower income than that. And so for a household of one, the average income for a Philadelphia VIP client is $15,000 a year. There is just no way that someone who is making $15,000 a year can afford to hire an attorney. But estate planning is so important for everyone, and to be able to use the resources to pass generational wealth of particularly a home onto the next generation is vital for, continuing to improve Philadelphia, to maintain communities. And we do a lot of work with homeowners, helping people with collections defense, torts defense, family law issues, custody support, divorce, guardianship. And we also work with small businesses and nonprofits to help with a wide variety of cases. But the essence is to help preserve the Philadelphia community. So for our volunteers, we have a lot of resources in that we do not do direct services. We are 100% focused on our volunteer attorneys. So the staff are here to support you. We work up cases in a way to try to avoid surprises when you actually get the case. Now, there are always going to be surprises, but when that comes up, that's when you reach back out to us. And we have mentors in the community that are experts in that area of legal work, or people that we can put you in touch with to both help expand your network in the legal community, but also to get some expertise on some of the issues that might come up. We have template documents on our website. We have a training guide, and that, again, you would have been emailed yesterday. So if you have any trouble accessing those resources, please let us know, but they're there for you to use. And we also have volunteer interpreters. If you're willing to take a case for a client whose native language is not English, we are always looking for people who are willing to do that. If you speak another language, we are really anxious to have you volunteer with us, because it's really nice for clients to be able to get counseling in their native language. We have office space here at the office where you can meet your client. A lot of our estate planning cases are done almost completely remotely until it's time to actually execute the documents. But if you and your client prefer to meet in person, we have space here. Just call us and we can help you schedule that. And then we have notaries on staff here at the office for document execution, but also a whole host of volunteer notaries who are willing to go to people's homes for clients who are homebound or have trouble with transportation or childcare. We can go to their home and help them get the documents executed. So there are lots of options. in estate planning, we have a case type that we thought we would start with, just a little scenario. It is a very common scenario of the client who might come to us. Often a client will come to us for estate planning, having heard some kind of word that they think that would be helpful. Either they've heard about a will, sometimes they've heard of a living will, or they want someone to help make their financial decisions, but they might not have the exact terminology, but they come wanting something specific. And then we can talk them through all the options of the different types of documents that we offer. So we offer simple estate planning documents. We don't offer complicated trusts. We're not asking you to draft anything that would not be typical run-of-the-mill financial power of attorney, advanced healthcare directive, and simple will. We'll talk more about each of those different types of documents. But in this case, when the client came to us and her husband had passed away, so her deed, while the house was solely in her name, it still has her husband's name on it. One of the services we offer is the deed of confirmation. So a client who has this tenants by the entirety, the property transferred to her as a matter of law when her husband passed away. That's how it operates in Philadelphia when it's held that way as husband and wife. Or if there was someone who had title joint tenants with right of survivorship. More commonly, if you're on title with someone who is not your spouse, but say a sibling or a child, it would be tenants in common. But it's the presumption in Pennsylvania, if they're spouses, that it's tenants by the entirety. And if you're not spouses, the presumption is tenants in common, but you can change it and make it joint tenants with right of survivorship. So when we, met this client for the first time, we had a conversation with her. Have you been having any trouble with your deed? You can show your deed and your husband's death certificate, and that should suffice to show that you're the sole legal owner. But sometimes it's just more complicated. And so it would make sense for her to get a deed of confirmation that says that she's the sole owner. So that's something that we would work up with her ahead of time, decide which type of case we're offering. Maybe we would be offering just a deed case. Maybe we would be offering an estate planning case, and maybe we would be offering her both cases. And it is up to you as the volunteer to decide which of those cases you want to work on, or if you want to help with both. So that's some of the preliminary work we do with her. Then we would talk about, you think that you want your daughter who lives there to get the house. Do you also want her to help you make medical decisions if you're unavailable to do it? Like if you can't communicate, do you want her to make financial decisions? These are all things we get clients started thinking about, but you as the volunteer really kind of dig into what Pennsylvania law says if you don't have these documents, and then what you might want to change by actually drafting and creating these documents. And sometimes clients surprise themselves by what documents they end up wanting in the end. But again, we've had some of these preliminary conversations with the client, and we've kind of narrowed down what documents they're thinking about. And you'll get all of that in the case summary that we post on our website, or that we send to you when we're asking if you're interested in that case. We have, as I listed out the documents already, the advanced healthcare directive is, one document in our template, but it has both the healthcare power of attorney and living will components. Some clients want some or the other or both.
So, excuse me, the powers of attorney, both healthcare and financial, allow for an agent to manage the principal's affairs when that principal can no longer do them. As Lindsay just mentioned, the advanced healthcare directive is that umbrella term for the healthcare power of attorney, living will, or a document combining the two, like our template. It's very easy to separate if you need to. You can ask us if you have questions about that as you're working through. So first, we'll talk about the financial powers of attorney. They can be general or limited. The general financial power of attorney is very broad. The agent will manage all aspects of the principal's finances. They can sell the home, access bank accounts, manage income, pay bills, anything that is necessary to manage those affairs. Where otherwise it can also be limited, where it's tailored to grant very specific powers. It may be just to access a certain bank account or to sell us a particular property. The principal's money or the client's money must be used for their benefit. Often you'll encounter joint or co-agents that clients are interested in. They must act together. They cannot act independently unless it's stated in the document that they can do that. While that is possible for our volunteers to draft, proceed with caution. It can get very complicated very quickly. We instead recommend that the clients choose one agent and an alternate in the event that first one cannot act. The financial powers of attorney that our volunteers prepare are durable. They will remain effective even when the client becomes incapacitated. Once the client executes the document and the agent signs the acknowledgement, the document becomes effective immediately. It does not wait for anything to happen to the principal. Once the document is executed and the acknowledgement is signed, the agent can use it. There are springing financial powers of attorney. They do exist. However, they are not recognized in most states anymore. It is also very hard to find a doctor who is willing to make the determination that the client or principal is actually incapacitated and unable to make those decisions. So our financial powers of attorney will all be durable for the most part. Some of the hot powers in the financial power of attorney, such as creating trusts, making gifts, are highly litigated. There are 20 other powers listed in the document that are designated by statute. They are all listed in our template. Just go through them with the client and they can pick and choose which ones they want, which ones they don't want, remove or strike out the ones they do not want. And it's important to note that an agent under the power of attorney cannot create a will on behalf of the principal or client. When drafting and executing the financial power of attorney, as I mentioned, it's better for them to pick an agent and an alternate rather than joint. And they should be picking an agent that they trust completely. As I mentioned, it takes effect immediately. So if they express hesitation about the person they're choosing, it might be worth a conversation. This takes effect immediately. Are you sure this is the person you want stepping into your shoes for your finances? The financial power of attorney must include a signed statutory notice by the principal. The statutory notice is controlled by statute, so it should not be altered. The power of attorney document must be signed and dated in front of 2 witnesses and a notary, and the agent should not be a witness. The acknowledgement can be signed later. It does not have to be signed at the same time the client executes the document. It also does not need to be notarized, but we do recommend it be signed in front of the client to make sure there's no risk of fraud. As I mentioned before, the agent will not be able to use the document if they do not sign the acknowledgement. So it can be a tool for clients if they want to have the document prepared in the event something happens. They can let the agent know that, look, I have this document prepared, but I don't want you to sign it yet. If something happens or I tell you to, then you sign it and then you use it. they shouldn't.
In the alternate, they can sign it, but just not give it to their agent yet. Have it in a safe place where only the client has access to it until the agent would need to act on their behalf.
Right. They don't want to prepare the document and not let the agent know it exists, though, because if something does happen, if the agent doesn't know it exists, there's no point to it. It serves no purpose. It is, as I mentioned, it's required to be notarized. Notarization does require a valid photo ID, and our lovely volunteer travel notary here will talk a little bit more about that later. But there are a couple of ways around that valid photo ID requirement if necessary. You shouldn't really have to worry about this. If anything does happen, you can reach out to us and we'll discuss it. But for your general knowledge, we wanted to let you know that as the client's attorney, if you are comfortable and willing, you can vouch for your client to the notary and express that, yes, I know this client to be who they are, and they can go ahead and do that. We are not asking you to do that. If you're willing to do it, you can. You do not have to. The other option is if the client knows a notary personally and the notary knows them to be who they are, the client can go to that notary and get their documents notarized. There are other ways, but those were the two that I think we see most often. So next we have the healthcare powers of attorney. The agent here is making healthcare decisions when the principal no longer can. Again, you want to have the client choose a trustworthy agent, someone who's familiar with their preferences and desires when it comes to their medical needs. Medical professionals are legally required to communicate with the patient first, so they will not turn to the healthcare power of attorney agent unless the patient cannot communicate directly with them. The living will is much more specific in when it can be used. Again, it can be in the same document with the healthcare power of attorney, or it can be separate. Our template can be separated as needed. Again, clients may choose joint agents. However, it's always a better idea to choose one agent and a successor. Ultimately, it does fall on the client. If they want what they want, they can have their joint agents. In drafting and execution, review all the powers with the client. They're all listed in the document. Again, client can strike out anything they don't want, and then initial near what they strike out. They can also, as you are preparing the document, you can also delete those lines from the document altogether. To execute these, it must be signed and dated in front of 2 disinterested witnesses. Again, the agent should not be a witness. If possible, it should be done in front of a notary. It's just better practice, but it does not actually need to be notarized. It can be fully executed without a notary. Again, if it will be notarized, they will need unexpired, valid, government issued ID to present to the notary. And then we have our living will. The living will outlines a client's wishes, which should be followed if the client has an end-stage medical condition and they are unable to communicate with the doctor. So these are situations where the client is in some form of terminal medical condition or is permanently unconscious with no hope of recovery. There is an actual definition, I believe, according to the statute. It's an incurable and irreversible medical condition that will, in the opinion of the attending physician, to a reasonable degree of medical certainty, result in death despite the introduction or continuation of medical treatment. Only one physician is needed to certify that the patient is in such a condition. And the physician certification is not intended to prevent treatment if the patient would benefit from the treatment, including palliative care, or the treatment will not merely prolong the process of dying.
So I would say that the living will is one of the hardest counseling pieces to do with a client. And part of it is, I actually just had a client call me yesterday. We had done her living will probably a year ago. And I think she had just had the conversation with her kids finally about what her wishes were. And she said, you drafted this document for me and it has a do not resuscitate in it. And I want to be resuscitated. And I said, okay, well, first of all, I know we can do a do not resuscitate document for you because we don't do those. So let's pull up your document. Let's talk through it. And what it turns out is, when you're talking about it, it's at this end stage, no hope of recovery. Do you prefer palliative care, comfort care, or do you want to prolong your life as long as possible? And people have very strong feelings about that, but it's hard to make that decision with the idea of, okay, she was saying, if I tripped and fell down the stairs, would they resuscitate me? Yes, if a doctor doesn't say you're in an end stage condition, then the living will doesn't control. If you're uncomfortable with it, we can change it, but you have to understand what it's going to be used for. And it should only be used in that end stage condition. And one of the things that is helpful about it is that if you have chosen an agent, or even if you haven't chosen an agent and it's your kids making this decision or your spouse making this decision, it helps give them the guidance of what you would want. So it's nice to have it if you're comfortable having it, but people, get uncomfortable. Is the doctor going to use this before they should? Is the doctor, going to misunderstand what my wishes are? So having those conversations and talking through what the options are is probably the trickiest piece of most of our estate planning cases. And so if you run into questions like that, or you want to have a VIP staff member with you when you're talking through, please feel free. But you don't want to wait until you're sitting in front of the notary and choosing which things to initial to have those conversations, because they are really difficult. So I would really encourage you to have the conversation with the client, make X's where they're going to be initialed, where they're going to initial during the document execution. And then, let them talk about it with their family, let them think about it, stew on it for a little bit. And I think that's the most successful way to have these conversations. And they can always change their mind. They can always rip up the document, come back, get a new one, and change their mind if they feel differently, 1 year down the road, 20 years down the road.
Some clients will also struggle with just having to think about some of those. So sometimes it's very helpful to just give them some space to think about it, maybe go through some of it and then give them a break and come back depending on their reactions to some of it. But the document really does provide some comfort, at least to the family members who might be having to make those decisions. And even your healthcare power of attorney agent, if you have one, it relieves some of that burden on them to be in a difficult situation with their parent or close family member something's going on with, and then having to make these decisions. This is the client saying, here's what I want you to do. You don't have to do this all by yourself. I'm still helping you through it. This is also something of a checklist. It can be turned into a statement format if the client prefers that. There is also space on the document where they can put general guidance for their agent if they want. Some of them want to, say, if there's any hope for me, bring me back. If there's no hope, then just let me go, or whatever they want you to say in there. There's always room, or room can be made for that. That's fine. Review the document carefully with them. This document, again, has to be signed and dated in front of 2 disinterested witnesses. It does not need to be notarized, but we recommend it. Any client having their documents executed in our office will have it notarized. And it's very important that you discuss with the client that they should communicate these decisions with their loved ones and not just leave it in the document, hoping at the moment it's necessary. That's when they're learning that, oh, wait, I'm supposed to pull the plug right now. It's important to share their values as well as their decisions, so their loved ones not only understand why they want that, but will more likely follow it and not be upset with the client for having to make that decision on their behalf. Anything you'd like to add? In that case, I will turn it over to Lindsay to talk about wills.
Do we have any questions on the power of attorney documents?
Sure. I just wanted you to please clarify which of the documents require notarization, because I heard what I think might have been a conflicting piece of information, but from what I understand.
So the financial power of attorney must be notarized. The healthcare power of attorney and living will do not need notarized.
I just have a question about copies versus originals, because when you mentioned, oh, you can always tear it out. Does that mean you should make multiple originals or give copies, or how do you recommend handling that?
So that's a really good question. Both financial power of attorney and advanced healthcare directives technically can be used with copies. Like, you can give your agent copies and then they can use it. And we do recommend that with especially the advanced healthcare directive. Give copies to your doctors now. Give copies to your agent. Let all of the medical professionals you work with have copies so that they're on record. That being said, once you've given out the copies into the world, more copies can be made. It's harder to tear it up. And so in that case, you would either have to create a document that actually revokes the prior document, or in a new document, it would say, I hereby revoke all prior power of attorney documents with the date.
Thank you.
Yes.
Exactly. So, it really depends. Financial power of attorneys, while technically the statute allows copies to be used, most banks are going to require to see an original. If someone needed to record something with the Department of Records, they would have to actually get the original recorded. And so the original financial power of attorney is kind of a much more sacred document. And if a bank does give issue with the template that we have, there is actually a statute that requires them to accept it. A lot of banks want it on their own form. They want you to come in and do it in their office with their form, but that's actually not allowed. They should accept a valid power of attorney.
So it might make sense to have 2 originals notarized at the same time, one for the client and one for the person with the power.
It might. We certainly don't recommend that for wills, because then it puts into question which is the actual original. But I do think that could be okay for financial power of attorneys.
I have a related question. Do the clients ever ask about storage options? Because I would think that sometimes it's difficult to find a safe place, and I don't know if you offer that. You probably don't, or what do you recommend when you get that question? Where to store these documents if you're the client?
Well, we don't store it. Law firms that practice in this area often will store the originals, and we don't do that. We send the originals home with the client, but we have an instruction sheet.
Yes.
It's in our template closing, like keep in a safe maybe fireproof box if you have one, keep it in a safe place where the agents and beneficiaries and principals and executors all know where it is
And can access it.
and can access it. So not a safe deposit box. Very, very important for it not to be in a safe
Yes.
deposit box.
And those same instructions and closing letter are in our updated manual, so you have access to that now too.
Mhm.
So usually somewhere where they keep all of their important documents in the home or wherever is usually where we recommend when they ask. But it's more us advising where not to keep it versus where to keep it.
Just if I could add, my aunt just died last week and she only had one.
I'm so
child,
sorry.
and nothing, and she has a safe deposit box and her daughter can't access it because she has no authority to access it. So we don't know if there's a will in there or not.
Exactly.
We don't know what to do, but she's getting an attorney in New Jersey, so they'll handle that.
Yeah, but never a safe deposit box.
Good point.
All right, so on to our wills, our simple wills, as we call them. Very few, we do have some template language for a testamentary trust if needed. If someone who is inheriting is under the age of 18, very simple language, who would be appointed trustee to watch over that asset until the child reaches a certain age. But we do not put in language in our general template for special needs trusts or for trusts for persons with disabilities that would do the counseling around protecting their benefits. So I'm starting with the more complicated. What I want to say is we really are trying to keep our estate planning simple, and we can refer clients to other people and other resources if their issues are more complicated than what we can achieve by a simple will. We do have a general template. We also have template language that we don't have in the general template. So if a situation arises where you think that like if someone has minor children and they want to appoint a guardian, or they want to leave something to take care of their pet, we have some of that kind of like more unusual, less frequently used template language. So please never hesitate to ask, and we can work through that kind of situation. But we just tried to stick with the most commonly needed language in our template. In Pennsylvania, all you need to be is over 18 and to sign a writing before 2 witnesses for it to be a will. And Pennsylvania accepts holographic wills where it's completely handwritten. However, we want to make this process easier for our clients and their families. So our template is what is called a self-proving will, so that it can be taken to the Register of Wills when someone passes and not require witnesses to go in to attest that is the signature of the person who has died, or do anything extra. The will should speak for itself, be taken to the Register of Wills, and easily be able to be probated by the executor. So that's our goal in doing this. And it's so important because if it is not used that way, then we get so many cases where grandma has passed away many, many years before. The family has been using it and treating it as a family home, which is wonderful, until someone needs to get repairs done or access a city program. And then there have been cousins who moved out of state and people who have passed. And so there's all these intermediary estates and different people in different locations. And the person who's living in the home and taking care of the home doesn't have record title and would have to probate estates and track down missing relatives. So the clearer the will is about who is going to be in control of the asset, the easier it will be down the road. It doesn't mean that whoever is inheriting can't change their mind. There are lots of things to do after someone passes, but for the client that we are counseling, our goal is to make sure that they know how to carry out their wishes, to make it as easy as possible for the people they want to benefit from their assets to benefit from their assets down the road. There's language in that self-proving affidavit that says that the testator had mental capacity, that the witnesses saw the testator sign, and that they were there witnessing at the request of the testator, that the testator is not under undue influence. And so that is what makes up that self-proving will. As some general language, the person who is drafting the will, our client is the testator. They are going to want to choose an executor. An executor is going to be the person who carries out the wishes in the will. And, you know, when I became an attorney, the first thing everybody in my family did was they made me the executors of their will. Great, thank you so much. I really appreciate that. It is not a benefit, it is a burden. And so when people are choosing who to pick as their executor, I think it's important to counsel. This is not some like badge of honor. You're not picking one kid over the other to inherit more. You're choosing who's actually going to carry out the duties of making sure all of this happens. Who's going to, you know, take all these administrative steps. And it might not be the person who's inheriting, although there is some added incentive to carry out the wishes if you're the beneficiary under the will. So, you know, some people want to choose like a trusted friend from church, and that is great if that trusted friend from church is really going to go to the register of wills, take the will, pay the inheritance tax, do all of these things. But it is more likely that the person who's benefiting from the will is going to take those steps. So it's just a really important conversation to have. They should choose someone that they trust. They should choose someone that they think is really going to carry out their wishes. Maybe have a conversation with that person in advance and make sure the person's willing. And like with the agents under power of attorney, it is more efficient to choose one person rather than co-executors who then have to go and do everything together. But again, it's a client's decision to do what they want. We just recommend choosing one executor and choosing some alternates so that there's choices. Beneficiaries are the people who are going to inherit under the will. So we try to gather as much information about the beneficiaries as possible. It's not a legal requirement to have their address in the will, but it helps because if the executor can't locate that person, it helps to have a last known address. That's sort of one of the biggest hurdles that we come across in, you know, tracking people down. A last known address is really helpful. So, you know, explaining what the relationship is so that the executor can help track someone down, knowing if someone has a disability and maybe is relying on SSI can be important to know and counsel. Now, just because you leave someone something in the will doesn't mean they have to probate the will and accept it, but you don't want to leave, you know, $60,000 to someone who is on SSI and relying on Medicaid, because while the money might be helpful, it might kick them off their benefits that they're relying on. So it's important to at least think about those things in advance and try to think about who could be a backup beneficiary, who should inherit, who shouldn't inherit. Is someone married? So in the example we started with, the woman who had property and she owned it tenants by the entirety with her spouse had passed away. If her spouse were still alive, but they had just been separated for the last 20 years, which is very common in Philadelphia because it is very difficult and expensive to get divorced. Her spouse could still have an elective share in the property by right of being spouse. So it is important to counsel and think about, you know, could this client be eligible for a divorce? Does she know where the spouse is? Could we put something in the will that maybe explains why she's choosing to write her spouse out? Because there is an abandonment statute. It's more than just sort of going your separate ways for 20 years, but maybe she can explain why she's writing her spouse out, and that could at least be useful if the spouse came back and tried to elect his share. Maybe the decision is to give that spouse something. So not the house, but maybe something else that would equal the value of what the elective share could be. So there's lots of different options. Some clients choose life estates for people. It's just worth thinking about sort of what the picture is of the beneficiaries who would either inherit if they went by intestacy law, and how you can change that by helping someone create a will. And there might be also reasons why someone wants to put in their will a very clear statement. I'm leaving my house to this daughter because she has been taking care of me. She lives here with me. It's not because I don't love my other daughter, but I know my other daughter is taken care of and has her own. So, you know, sometimes people just want to put some more personal things in. Another thing that we get a lot is people want to put their wishes for their burial in their will. That's fine. We don't have template language for that. Excuse me. But it's not really legally binding. Most people will be buried long before their will is actually probated. So it's often nice to just put a letter on top of the will somewhere where their heirs will find it, where their family and loved ones will find it once they've passed away, if that's something that they feel strongly about. I've already talked a little bit about how clients hold property to their homes, and often with VIP clients, the home is the biggest asset, the reason that they've come into our office to get a will. But there might be some other personal property that they want to distribute, cash, jewelry, furniture, a very special quilt, something that is meaningful, that can be listed out individually. In prior versions of our template, we have had what is called a tangible personal property memorandum. We've taken it out because we find that it's not easy to use with our will template. We have it if people want it. It's not very clear that it is acceptable in Pennsylvania. There's no like clear case law that suggests that it would be recognized. The best way to use it properly is to explain in the will that there is going to be a tangible personal property memorandum, have it separate. The reason that it's useful is that it's, you know, you can leave this sweater to that granddaughter, this, you know, ring to that granddaughter. And if you change your mind, you can redo it without completely redoing the will. That's the benefit. The risk of it is, especially for anything really valuable, for anything that there might be dispute about, it should be in the actual will itself and distributed with the other specific personal property.
We've also found that clients don't really understand it that well, that it's for their not heavily valuable assets, and they're quick to stick their house in there, even though it's already taken care of in the will. So we decided, let's remove it. If they really want it, we have it.
And then the last big section is the residuary clause, which is where anything that you haven't thought about, some, you know, pension that they didn't even realize that was going to pay out when they passed away, or a bank account that, you know, I don't know what the different things were, but anything that not specifically captured is taken care of by the residuary clause. And it's important to have a beneficiary and then alternate beneficiaries, and to choose, you know, if they're leaving it to all three children, is it going to all three children? And then if one of those predeceases, is it going to be split among the other two, or is it going to go to the one who predeceased, their heirs? So different ways of doing that, but important to think about. Life insurance is something we really do like to talk about because it is a non-probate asset. It does not have to go through the estate. And so one counseling piece is that it is very important to let your client know that if they have life insurance, it is better to list the beneficiaries with the life insurance company rather than have it go to your estate. Because if it goes to your estate, it's subject to inheritance tax. If it goes outside of your estate directly to the beneficiaries, life insurance is one of the few things that can be exempt from inheritance tax. So that's just something that's worth talking with the client, encouraging them, you know, for any of their retirement accounts or anything that offers to list beneficiaries directly, it's often a really good idea for them to go and take care of that with that specific company. And then if anything, for some reason, does not go through the beneficiaries directly, it will pass through the residuary clause of the will.
That reference in the will itself, do you reference?
I mean, you can say it, but it doesn't have to. But it does help for their executor to know all of those different account, advise your client to keep those papers all together with the will. For the execution of the will, it is very similar to what we've already discussed. I don't think we need to go into great detail about that. But that self-proving affidavit is a very important piece of it. And a will should have 2 witnesses and a notary in order to be self-proving. In representing your VIP client, you are helping do all of these things that we've been talking about: preserving intergenerational wealth, having difficult conversations with their family that people want to avoid. But drafting these documents starts the conversation, helps them think about what their wishes are, helps them have some control over their end of life care, and can be a really nice empowerment tool for everyone. I can't tell you how many friends I've yelled at in just the last week that they have not done estate planning and they have children, and you have to think about these things and have these conversations even though you don't want to. The nice thing about your VIP client is they've chosen to come to us. They want to, it might be difficult, but they've already made the decision that they want to have this conversation. So we will, going back to that case example that I showed you, we have summaries like that. You can reach out to a VIP staff member. You can go on our website and select a case. We will send you conflicts to make sure that you can clear a conflicts check. And then we'll send you a case file. It will have all of the notes from our conversation with the client. It will have their basic contact information. It will have a copy of their deed so that you know what you're starting with. You can be assigned a mentor. You can talk with VIP staff. You'll have that initial meeting with your client to get to know each other, figure out how you're going to proceed. We have a questionnaire that can be helpful to sort of figure out what all the client's assets are and make sure that you're counseling them. It's very over-inclusive, so don't need to go through and have your client fill out every single answer, but it's just a good starting point for your conversation. You can also use the template documents as a starting place for your conversation. Our training manual has information. Our templates are there as your resource. Counsel your client, but ultimately the client's decisions are the client's decisions, and you want to reflect those in the document, get the final drafts, and then schedule a meeting to come in and sit with us here at VIP or at the client's home where the client can notarize. And this, to your point, Lisa, is sort of our breakdown of what is required and what is suggested for document execution. Again, remembering that photo ID is very, very important for them to bring for notary purposes. I will now turn it over to you, Lisa, if you want to maybe come sit in my chair and just share with us some of your thoughts.
Hi, I'm Lisa Joy Phillips. I'm a traveling notary here in Philadelphia. And I just wanted to talk for just a minute or two about identification. One of the things that happens in my work is that I'm a neutral third party, so I can't advise anybody anything. I am neutral, but my biggest role is to look at the signer in front of me, check their ID, and look at the document to see how their name appears on the document. If their ID can't substantiate the name, we run into some issues at times or challenges. We're fortunate if we're sitting in the client's home because often they'll have some supplemental ID that can be helpful. Situations that come up have to do with the use of a middle name or middle initial on the document, but the ID does not have that middle name or middle initial. Suffixes like junior, senior, the third, etc. married name versus maiden name. Even elderly clients can sometimes have an ID that has a maiden name on it, even though they've been married for many, many years. Their spouse may be deceased at this point, but for some reason they never changed the name on their ID. But in speaking with their attorney, they gave their married name, and that winds up on the document, and then we have a mismatch, and the notary by law cannot notarize unless there's some other piece of ID that can substantiate the name that's on the document. A couple things to know is that in Pennsylvania, according to the statute from the Secretary of State, we can use, we definitely want, first thing we would always love to see is an unexpired photo ID that is government issued, like a driver's license, state ID. Philadelphia has its own ID now, a military ID. So passport, many of your clients may not have a passport in this particular situation, but a passport is very helpful because often it will include the middle name, will include a suffix after the name, etc. But there are two more things that often are helpful with elderly clients, and those are, and even not a non-elderly client, a signed social security card is as permissible as an ID. In situations that I run into, many elderly clients, especially over the last few years when COVID hit, were not able to get out and get have their driver's license or state ID renewed. So they may have an expired ID, which has a photo on it, which is great because it's one way to identify them, but we do need something else to identify them. And as long as the government issued ID has either a photo or a signature, it is acceptable. So the two that I see the most often are a signed social security card and or a signed Medicare card. Something to know about the Medicare card is that, I don't know exactly the year, but used to be in the old days, they were printed with a signature line for signature. The newer ones don't have a particular signature line, but as long as that Medicare card is signed before the notary walks in, it could even have been 10 minutes before, and includes all parts of the name that are on the document, the notary can accept that as an ID, and that can be really helpful. I wanted to mention one other thing just as I was listening to the presentation, and that has to do with when you prepare a document that might require initials of your signer, initialing this item, this item, this item on either the durable financial power of attorney or the healthcare. Consider the particular client you're working with. I did hear the instruction that you could also omit certain things if they're not going to be included on the document, which can make it easier for a signer who may have difficulty in physically signing the name over and over again, and again, having to initial all of those spots. Something just to consider. Again, you'll know in working with your particular client what the capabilities are. And again, if you can look at the ID before you start to draft the document, it's going to save you a lot of time when you're in front of the notary. So thank you.
Just a clarification on
Yes.
this. So we want to put the name in the document that is the identical name on the ID that they're going to be
Okay.
using.
I'm going to be very careful here. I cannot advise.
I
So
understand.
you can make your decision, but do not include anything extra on the document that is not on the ID. That's what I say. I have to be very careful here.
Yeah.
So you
With
can
respect
do,
to VIP client information,
Yes.
if when we're meeting with a VIP client and they're using a maiden name, but their
yes,
documents, their license has
So,
a married name, what
yes.
is that we put in their documents in order to allow them to get it notarized and make it legal.
Yes. So I'm not sure if anyone on Zoom could hear that. So the question was, if a client is using a maiden name on their document, but their ID has a married name, what would happen with that? You can do an AKA on the document and put Jane Doe, AKA Jane Williams, and continue going. So the ID will match at least one of those and recognize that, okay, there's also other things in this person's name that has Williams or Doe.
And that might be helpful if when you're looking at their deed, you see maybe the deed is not in the name that they're currently using, but you can kind of identify how it's on both their identification.
Again, I don't know if anyone heard that. Lindsay was just adding that the deed sometimes where client owns the property will also have an AKA or a different name from their ID. So you'll want to use both of those to make sure that the will is referring to the right property and the beneficiaries won't hit any issues when trying to obtain title.
So do we have any final questions?
I have one last question. I'm just curious, how long typically does this whole process take? I mean, let's say if the client wants all of the documents we just talked about, typically how long does it take?
I would say, for a first time case, it usually takes around maybe 12 hours would be a safe estimate of, meeting with your client, taking some time to draft. But some volunteers who have been doing this and, they can do it in 2 hours. So it really depends on, how many conversations you have with your client, how many back and forths there are, and how long it actually takes you to sort of sit and draft and think about it. They're not long cases that take many, many months. Although it, sometimes the client will fall out of touch, this loses priority, and we're here to help you make sure that you get back in touch with your client, use us as a resource for that. But altogether, it should take maybe 1 or 2 meetings in advance in exchange of some documents, and then the final document execution. So it does really vary.
If I can add, and I don't know if anyone can hear me, but the more detailed you can be in capturing information on the questionnaire, the better off you are going to be. I did this the last time around, and as you start filling out the template, you get to questions and you think, oh, I don't know this answer. For example, what is the address of the executor? And you have to then call or go back to your document. So the more you gather when you're meeting with a client, I'm finding the better prepared you are to prepare the formal documents. So it's a conversation and it's a documentation of all the information. So you almost have to work from the end backwards to know what you're gonna need to make sure those questions are asked. And I found that that was clearly laid out in the questionnaire. I wish I had paid more attention to the questionnaire.
So I'll just repeat that. One of our lovely volunteers recommended being as detailed as you can when going through that estate planning questionnaire with the client, which we have on our website and in our training manual. It'll set you up to prepare the documents with as much information starting out than having to keep calling the client back for additional information as you go through.
And do we have a question in the chat?
We had one question for us to share the PowerPoint slides, which we can absolutely do.
We'll happily do that. I will also add that Lisa Joy noted that we need to update a small portion of our will template where the notary signs, and so we will be updating that link and posting new templates to our website after the training. But if you ever have any questions, please just reach out.
Lindsay, I'm sorry. I had a couple questions I've saved up. I hope you don't mind.
Absolutely, go for it.
Okay, on the financial power of attorney, there's one power that is to create or change rights of survivorship. And other than a deed, what else, when would you ever see survivorships appear? Because that's a common question from a client that I never really knew the answer to.
I mean, there are some bank accounts that can be jointly owned, although I would think that changing that would be different than changing ownership of a property. A car could be another example. Anything that you hold title to.
And flipping over to the will, the slide that you had, the life insurance discussion also listed joint accounts and transfer on death accounts.
Mm-hmm.
Those are also outside of the estate, is that right? And a lot of times you have elderly clients who have their children already listed as account holders. What is the mechanism for those joint account holders? And a lot of times they're also the executors. The money doesn't come into the estate. It's up to them to distribute it. It becomes they become the sole owner, but that wasn't the client's intention. What would you advise for that?
Yeah, so they become the sole owner, and often a bank will want a short certificate to take the person who died name off the account. But depending on what type of account it is, most of those, other than life, not all of them, like the payable on death account, I think the funeral insurance accounts, there's so many different names. But those are exempt from inheritance tax, but if you just own a joint account, it is still subject to inheritance tax. So there should be, the executor needs to know about all of the different accounts so that they can be listed on the inventory and the inheritance tax return when appropriate.
Okay, and that goes to my last question. Can you give us like a quick and dirty on inheritance tax? I mean, most of these people leave their assets to their children who are not required to pay tax, correct?
Yes, and on the very last page of our training manual, there is an appendix, and there is a link on that is a guide to inheritance taxes. And it is something that we should have mentioned. We often advise to print that, or it's a probate guide. We also have an inheritance tax guide, and they can be printed and kept with the will, so that whoever is the executor, when they get the will, it has some instructions on what would happen, how they go about probating the estate, and how they go about doing the inheritance tax return. The nice thing for spouses in Pennsylvania is that the inheritance tax rate is 0. So while technically you should complete an inheritance tax return when your spouse dies, no tax will be owed. For family members, close family members like children, the tax rate is 4.5%. The inheritance tax return itself is fairly self-explanatory, in that you list out the assets, you list out any expenses, a mortgage, the funeral costs, any deductions that you can take from the value of the estate. And it is, I say this as someone who does not like math, it is fairly simple math. Like, you add up the assets, you add up the expenses, you subtract the expenses from the assets, and then you multiply it by the rate. So again, we have a guide that is probably more informative than that was, but that's the short story of inheritance taxes. Justina, did that answer enough of your question, or is there a specific inheritance tax return?
No, and I'm glad I asked, because I thought children were exempt also.
Mm-mm.
And then the other question I had for the memo, and I understand you're kind of leaning away from it, but how is the best way to say I leave all my household furnishings and personal effects to my 2 children, except for those items listed on the memo that's going to be attached to this will?
Exactly.
Okay.
Yep. I think that's a really good way to handle it. And then the client can change that as many times as they want.
Right.
But we do, in our closing letter, we do encourage, if clients want to change their documents, they should feel free to come back to VIP. If they're still eligible for our services, we will open a new case for them, help them, or provide resources where they should go if they're no longer eligible for our services. So, when big life events happen, someone has a new child, someone has passed away, it's always good to revisit your estate planning documents. And so we encourage clients to do that, and they can come back to us to help do that.
And what is the percentage of the spousal election?
It's 30%.
And is there a time where they have to make a claim?
That is a really good question. It depends on how someone probates the estate, I believe. So a lot of our clients will do at-risk distribution and not publish, just because it is so expensive to publish. I think if you publish, anyone who is coming after any of your assets from the will has just 1 year, but not everybody publishes when they're probating an estate. Any other thoughts or questions as we're wrapping up?
We had one volunteer advise that we'd spoken about the healthcare power of attorney and living will not needing to be notarized in Pennsylvania. However, other states Some other states like Florida do actually require them to be notarized. So it's recommended in case clients move down that way. I also wanted to mention that our updated templates all have revocation language at the start. I don't believe they had that before, but they now do. So that's not something, if they come back and ask for new documents, it'll have that revocation at the top. And I know we were talking about the financial power of attorney being difficult to revoke. I think it would end up being on the client to provide a copy to their financial institutions of the newer documents. So they already have it on file. They know, okay, well, we can't work with that agent anymore. We need to work with the current one.
One last plug for VIP, if you take a case, you are eligible for up to 3 CLE credits. We can offer 1 credit for every 5 hours worked on a case closed in that compliance period. So you can get CLE credit for doing pro bono work. And again, we are so grateful for all of you, and thank you, Lisa, for participating and sharing all this knowledge with us and for all that you do for our clients. We are really grateful to all of you. Please reach out with questions or any interest in taking a case. Thank you. Bye, everyone.